You ever wonder what happens to all those papers ICE fills out when they slap a detainer on someone? They do not vanish into some government shredder. They sit in a file waiting for someone brave enough to ask for them. That someone can be you, and the tool you need is called a FOIA request, short for Freedom of Information Act. Think of it as a magic spell that forces the government to hand over documents they would rather keep collecting dust. Here's the twist nobody tells you. ICE and DHS are actually two different beasts with two different mailrooms. If you send your request to the wrong one, it is like mailing a birthday card to your neighbor when the party is 3 houses down. So step 1 is figuring out exactly who has the records you want. If it is a detainer form on your client, that usually lives with ICE, but if you are hunting for a policy memo that shaped how detainers get issued, you might need DHS headquarters instead. Now let us talk about writing the actual request, because this is not a place for fancy lawyer language. You want to be as specific as a detective, naming the client, the alien number if you have it, the date range, and the exact type of document you are after. Vague requests are the #1 reason people wait forever and get nothing useful back. Imagine ordering food by just saying you want something with bread. The kitchen is going to guess wrong every single time. A cool little pop culture comparison here. This whole process is kind of like ordering a custom pizza from a place that moves at the speed of a sloth on vacation. You have to be specific about every topping or you end up with plain cheese and disappointment. Once you submit it, the agency has 20 business days to respond under the law. Reality check though, government offices treat that deadline like a suggestion rather than a rule, so patience becomes your best friend. If they deny your request or go silent, you are not stuck. You can file an administrative appeal. Think of it as sending a strongly worded letter that says, "Hey, you forgot to actually follow the law." A lot of people assume FOIA only works for journalists or nosy conspiracy folks. That is a total myth. Immigration attorneys use it constantly to build defense strategies and prove how ICE actually operated in a specific case. Sometimes those DHS policy memos reveal that agents were told to follow one set of rules while your client got treated completely differently. That gap between policy and practice can become the heart of a legal argument in court. There is also something called EOIR, the immigration court system, which sometimes has its own record requests separate from ICE and DHS. Knowing which system holds which paperwork saves you weeks of chasing your own tail. A little historical nugget for you. FOIA became law back in 1967, long before anyone imagined it would be used to track detainer paperwork. It was built for government transparency in general, and immigration law just found a very practical use for it. The real lesson here is that persistence beats perfection every time with FOIA. Keep your requests clear, keep copies of everything you send, and keep pushing when the silence gets loud. So next time your case needs proof of what really happened behind the scenes, remember this whole roadmap exists for exactly that reason. Want to learn more about how our team handles cases like this? Check out our links in the description.